All right, we're on the record. We'll take up two matters. File 2018-55985, Julia Ross and Jeffrey Ross, and file 2017-55005, Jessica Luno and Jeffrey Ross. Mr. Ross is here on both matters. The other parties have not appeared. Both matters are set for hearing to address bench warrant regarding support. And sir, I'm the referee of the court assigned to handle these matters. At the conclusion of this hearing, I'll make a recommendation that'll become a court order. You do have the right to have an attorney represent you. If you wish, you could hire an attorney, or I could appoint an attorney for you, or you could proceed on your own without an attorney and represent yourself. You know what you'd like to do?
I'd like to proceed if possible.
Okay. Ms. Evans, do you have an update? All right.
I do. In the 2017 case versus Jessica Luno, Mr. Ross is ordered to pay $167 support to the state of Washington, plus $84 ordered on arrears. He owes the state of Washington $24,324.13. Fees owed here $148.50. Total owing $24,772.93. Last payment received on this case was $81.46, November 20th, 2020, and $51.08, August 8th, 2019. There are prior contempts. This is a failed to comply, issued July 28th, 2021. The 90-day jail sentence or $1,000 cash bond. He was lodged in the Newaygo County Jail on February 10th, 2023. And in the 2018 05985 case with Julia Ross, he is ordered to pay $165 child support, $12 medical support for a total of $177 and $50 ordered on arrears. He currently owes the plaintiff $9,804.32, the state $713.15, fees $468, total owing $10,985.47. Last payment received was $118.54, November 20th, 2020. $250 bond, June 29th, 2020. $74.33, August 8th, 2019. There are prior contempts. This is a failed to comply, issued July 28th, 2021. The 90-day jail sentence with $1,000 cash bond.
All right. And sir, do you agree that you owe the amount stated in each case?
Yes, sir.
All right, and so you've not been making payments, and a warrant was issued. Do you have the bond, $2,000 total?
Don't have 2,000, but I can get money though.
Oh, how much can you get?
How much would you guys needing by chance?
Well, bonds are set pretty low. I mean, I don't know how much you've got, but one of them is set at 1/24 of your arrears. The other is at about 1/10 of your arrears.
Yes,
usually it's set a little bit higher. I don't know. Is there a reason you haven't been paying?
Recently, no. I don't want to give no excuses at all. So I've been a stay-at-home dad. But I do have at Wednesday at Tube Light in Reed City. I do have an interview there through Arch Staffing out of Big Rapids.
So if you've been a stay-at-home dad, that would that lead me to believe that someone else is working and paying the bills?
My girlfriend, yes.
All right.
Yes.
Why didn't you use some of her income to pay on your support?
I
mean, I don't care if you work or not. If the support gets paid, if you've got other resources in the home to buy food and shelter and all that stuff, then,
yes, sir.
So this is one of the bills that has to be paid in order for
yes, sir.
For you to be able to be the at home, I guess.
I understand. I definitely want to start getting this taken care of and getting it behind.
I guess the bonds are already set pretty low. I don't know that they can really go a whole lot lower. I don't know what the feedback is going on there, but
we any at all?
What's that?
I say, can we lower it any at all? I know it's set pretty low right now.
Well, I asked you how much you could post. You didn't really give me an amount. Yeah.
I think we lost sound.
Oh. Sir, can you hear us?
Hello?
Yeah, I can.
Yes, sir.
Oh, there you are.
Yep.
I guess, I mean, it's been 2.5 years since your last payment. It's not like it's just been a couple months here or there, you know?
I understand. I definitely want to get this started taken around too.
Well, I got someone looking in the window. Was someone coming here on your behalf, do you know, or?
No.
All right, okay. At this point, it appears that Mr. Ross had the ability to make payments, failed to do so, for a period of going on 2.5 years here with another year since the payment before that. The bond's already set pretty low at this point. The sentence would be imposed 90 days, $1,000 bond on each case. I guess if you find out you can come up with something close, but not quite 2,000, let Ms. Heaven know, and we can revisit this.
How about 1,400 today? Yeah, would that work?
Who's got 1,400 to post?
Actually my girlfriend. I talked to her last night. That's what we can come up with. That's what she has right now.
All right, yeah, well, you understand part of that would be that you got to start making payments each and every month.
Yes, sir. Yes, sir.
Otherwise, we're just going to be right back in this position a year from now.
Yeah, I don't want to be back. I don't want.
All right, I'll drop the bond to 700 on each case, so you could be released when 1,400 is paid. All right.
Can I get a paper of what I owe each month so I know exactly what I need to pay and who to pay?
Yeah, you can come talk to Ms. Heaven after you get out. She can
Oh,
set
okay.
you up with that information. She's over here at the other building in the front of the court.
Okay.
All right, technically, since I'm imposing the sentence 90 days, but even though I'm dropping the bond, you have the right to appeal my decision to the assigned judge, or you could accept it. You know what you'd like to do?
Yeah, I'll accept it. Yeah.
All right. All right, we'll take up 2012-51290. And this is the matter of Samantha Cooper and James Taylor. And Mr. Taylor an adjourned hearing on his motion regarding parenting time. Mr. Taylor filed a motion regarding parenting time back in July. The matter's been adjourned a couple times because the other party hasn't appeared. And she's been ordered to turn over the name of the counselor or therapist's name by December 30th, 2022 at the last hearing. Did she turn that information over to you?
Nope.
No. All right. And Mr. Taylor's appeared for hearing today. Matter was set for today at 3:30. It's now 3:45. And Ms. Cooper has not appeared, although in the last order she was ordered to appear with the notification that failure to appear as ordered would subject her to contempt powers of the court. Is there anything you want to say today?
I just like to get it figured out. I would like to be able to at least start being in my son's life. It's been quite a long time, and I did straighten up a lot more than when I did leave out of the picture. And I wish she would co-parent. It'd be so much easier if she would just co-parent and be a parent, honestly. Because if you can't co-parent, you can't parent. Both parties, I think, should be able to see their kids.
You had any contact with her at all?
I tried messaging her on the old Facebook I had from her, and I get no response.
All right, at this time, Ms. Cooper was ordered to appear. She's failed to do so. She's also ordered to turn over the counselor therapist name to the defendant by December 30th, failed to do that as well. For those two violations of the order, I would find her in contempt for failing to appear today and failing to turn that information over. There'd be $100 contempt sanction for each contempt finding payable to the circuit court clerk within 90 days. The order would continue that she's to turn over the name of the counselor or therapist to the defendant as previously ordered. There's not an order of legal custody in this matter, so I'll enter an order for joint legal custody, giving either party the right to have access to school records or medical or counseling records of the child.
I don't even know.
Joint legal custody. It doesn't give you the right to contact the child at this point, because I was gonna wait until I had the counselor's recommendation, but it would give you maybe more tools to try to find out who the child's counselor is and the right specifically to get that information as a joint legal custodian. Physical custody is where kids live the majority of the time. Legal custody is the right to have access to and input into educational and medical care decisions, which this would certainly be part of that. So hopefully that would give you more tools at your disposal to attempt to find out who the counselor is and get that information that you're looking for.
I have tried to call multiple hospitals, doctors' offices in the last place I knew she lived, which was in Muskegon. And none of them can give me information. So it's like, I feel like I'm hitting a dead zone.
You'll have an order now that says you have joint legal custody.
Okay.
And that's pretty widely known in the education and medical community that with joint legal custody, a parent has a right to access that information. So that's why I'm doing that. Your motion was for parenting time, but the avenues that we've tried to have her comply with an order for you to have, you know, the counselor's recommendations or the counselor's opinion doesn't work. She hasn't appeared. So I'm going one step further and granting you joint legal custody so you can try to get that information. Because essentially you're on equal footing with her now as far as access to that information goes. Okay?
Yep.
All right. Good luck to you.
Yep. Thank you.
If and when you want, you can file more paperwork, but at this point, I'm not gonna set it for another hearing. See what you can find out if you want to file.
Okay.
You can, but I guess I'll put in here with counselor recommendation. Parenting time could begin. I think that was already in the order as well.
Okay.
All right.
Yep.
Okay.
Thank you.
Take up file 2021-57605, Sarah Morris and Michael Morris. Mr. Morris is here from the jail. Sir, I'm the referee of the court assigned to handle these matters. At the conclusion of this hearing, I'll make a recommendation that will become a court order. You do have the right to have an attorney represent you. If you wish, you could hire one. I could appoint one for you if you couldn't afford one, or you could proceed on your own and represent yourself. Do you know what you'd like to do?
I guess I'll just proceed, sir.
Okay. Ms. Evan, do you have an update in the matter?
I do. Michael Morris has a monthly support obligation of $245 child support, $29 medical support, for a total $274 a month. There have been no payments on this case. The balance was transferred over from a 2015 DS case in July of 2022 with the judgment. He currently owes the plaintiff, Sarah Morris, $19,503.48. The state, $2,593.26. Fees, $432.50. Total owing $22,529.24. There are no prior contempts on this case. There were 5 bench warrants issued in the 2015 case. And the last pay before it was transferred was January 20th of 2021 from unemployment, $640. There are no prior contempts on this one. Failed to comply, issued February 8th, 2023. It's 45 days or a $2,500 cash bond. He was lodged in our jail on February 20th, 2023.
Sir, do you agree that you owe the amount stated?
I'm sorry, you said, when was my last payment?
2 years ago, January of 21.
That's not right. The temp agencies have been taking money out of my check to pay my child support. I let them know even.
Have you seen,
Nothing.
I worked at Wolverine, the pay that I got for Big Rapids products. I just got laid off at Wolverine just a couple, like maybe a month ago, and I've been doing DoorDash. I just started DoorDash last week. I was gonna pay out my child support today because my money for DoorDash don't go on until Tuesday. I was also supposed to go to Manpower with a friend of mine to get into Parker, which is right across from where I live pretty much.
well, tell
I
me
could have
this.
sworn I was paying out my child support.
Just a minute. Tell me this. Where were you on December 14th? You were supposed to be at a show cause. You didn't appear.
I did not know that. But I could have sworn my child support's been being pulled.
So you would have received a pre-show cause notice back in October. That should have alerted you that your support wasn't being paid. Then you would have received the notice of hearing, actually the order to appear for the show cause hearing. That should have been an alert that hadn't been paid. Then you would have gotten an order in the mail after the hearing, telling you what happened at the hearing. And then, last but not least, you would have gotten a copy of the order imposing the sentence and the bench warrant. You should have gotten 4 pieces of mail, any of which would have alerted you that something was going on. You needed to dig into it a little
I
bit.
didn't get any mail. I don't live at that address anymore.
Okay. When did you?
I gave when I emailed you guys, I called in front of the court and gave you guys my new address too over here in Morley. So there's something wrong on your guys' end. There's got to be, because I've been paying my child support, and I changed my address and got a hold of you guys.
Well, Ms. Evan, did you receive an email with a new address?
No, I have nothing in my email. So I don't know who he emailed. The last address we have was from a bench warrant interview, May of 2022.
So May of 2022, your address was confirmed.
That's probably the Shelby address, which I don't live there anymore. I moved out of that address in July. Because that's the last time I seen you guys too.
Yeah. So where you been working since
Well,
then?
I've been staying over here in Morley. I worked at Big Rapids Products. I recently got laid off at Wolverine, and Advanced Employment I've emailed them and called them, and they have not gotten back holding me at Parker. So a friend of mine said go to Manpower and go through them, which was what I was going to do today.
And you notified the friend of the court each and every time you started one of those new jobs?
I let the temp agency know that I have child support I have to pay.
That's not my question. That's not my question. My question was, you let the friend of the court know when you started those new jobs?
No, I didn't. I guess I just
Temp
assumed that
agency
you guys
doesn't
would know.
Telling the temp agency doesn't do any good. You have to let the friend of the court know. That's what it says in your order.
They do handle that though. They do take that out for me.
They might take something out, but the friend of the court has to send an order to the employer in order for the employer to take anything out.
What about ARC staffing?
I don't know.
Because I had even gotten some paperwork from them saying that you guys had that was done.
So ARC Staffing, Advanced Employment, Wolverine, and Big Rapids Products. Anywhere else that was supposed to take money out that did not?
Well, Wolverine and Big Rapids Products are through those 2 temp agencies.
Okay.
ARC Staffing, Advanced Employment. I'm sorry, On Point.
On
On
point,
point was,
So Arch Staffing notified us on July 13th, 22 that you were termed. We received a new hire download on January 18th of 23 regarding On Point. But we've never received anything from any of those income withholding orders.
I only got
As
half
far
my
as your
pay when I-
You told the jail your address was 217 North Michigan Avenue in Shelby. You
Yeah, I
didn't
don't
even give
live
the
there.
jail your proper address.
Yes, I did. I did live there.
No, but I'm saying that's the address you gave the jail on booking.
Yeah, are you talking about this time?
Yeah.
No, I didn't. I gave him my Lakeview address.
Well, then they didn't update it.
you just said, is it Morley or Lakeview? You said Morley a minute ago.
Well, Morley. I gave you guys my Morley address, 11196. And then when I got booked in last night, I gave my Lakeview address, which is 111 6th Street.
All right, you're saying that your paychecks were light, so there was something being withheld?
Yeah,
All right.
because
We'll,
I was not, because I wasn't joking when I told you I was gonna try to prove to you that I was gonna do this, and I thought it was handled.
all right, we'll adjourn this till Thursday at 3 p.m. In the meantime, Ms. Heaven will call those employers and temp agencies and see what she can figure out. If money was withheld from your pay, as you indicate, I want to make sure you get proper credit for it. But according to Ms. Heaven, nothing's been actually paid to the front of the court. So I'm going to have her do a little legwork and see if she can figure that out. We'll reconvene in about 48 hours, 3 o'clock on Thursday, and see what she can find out. All right.
Okay, is it all right if I put I can put 100 down right now, and my roommate can also help me put something down too today.
Yeah, the bond's 2,500. You know, you haven't paid in 2 years. You're 22,000 plus behind. I'm not going to let you out for $100.
Okay,
I'll see you in 2 days. All right, we'll take up file 2021-57605, Sarah Morris and Michael Morris. Mr. Morris is back. I had adjourned this matter 2 days. To give Ms. Evan time to look into Mr. Morris's claims that money was withheld from his pay at various employment agencies and employers. Ms. Evan, did you have a chance to contact any of those employment agencies or employers?
I tried reaching out to Arch Staffing. I did not get any response from them. The other three that he listed, there's not even any Michigan quarterly reporting out there, so I did not call them. They're not gonna, I mean, if they didn't report any quarterly reporting or new hire, then he wasn't ever on their system.
All right, so sir, you didn't have any income for those quarters that was reported to the IRS. So I don't know how money could have been withheld from your pay if there was none.
I don't understand either, sir.
All right, anything else you wanted to address?
No, sir. What is my bond, 2,500? What would I need to pay in order to, I guess, be released? Would I have to pay the whole thing?
2,500, yeah, it's not criminal bond where you pay 10% usually. It's a civil bond where you can be released as soon as it's paid.
Okay.
How much do you think you can pay?
Well, my roommate said that she talked to a bondsman. Well, the longer I sit, will my bond go down?
Well, not necessarily, but you know, if you find that you can come up with a substantial amount of money, even if it's not the entire amount of the bond, you can contact Ms. Evan and she would have the discretion to lower your bond, or if she didn't feel it was appropriate, she could set it for a bond review hearing, and I would listen to what she had to say.
Okay. Um, a couple weeks.
Well,
Can I set one up in a couple weeks?
well, I'll impose the 45 days with the 2,500. If you come across information that someone will post a significant amount toward that, let Ms. Heaven know. And like I said, she could reduce the bond if it's reasonable in her mind. She has the discretion to do that, or she could set it for another hearing and you can tell me how much you have and we'll see how much you've served and take it from there, I guess.
Okay, so right now I'm 45 days.
Yes.
Okay,
All right, so
All right.
since I've imposed the sentence, I'm a referee and not a judge. You do have the right to object or appeal this decision to the judge. And that would be set up as soon as possible, or you could accept the sentence, 45 days, 2,500. With that provision, like I said, I would listen, I would hear you out if you came up with some money somewhere along the way.
yes, sir.
Did you want to object and have a hearing with the judge or accept the sentence?
I'll accept the sentence, sir.
All right, you're all set then. Good luck to you.